Good evening, everybody. I, on behalf of Beyond Law CLC and ULS Punjab University, Chandigarh, welcome you all to another session wherein we thought that one should go. What are the latest trends, the contemporary trends in March of law? As we all know, as a matter of fact, that the law keeps on evolving and it goes with the flux of time in terms of the contemporary requirements of the society by large. It also works in terms of the jurisprudence, etc. We thought that on the platform to discuss the vital issue which boggles in the mind of any student, professor, or lawyer, as well as the judges, as to what are the march of law which has been there, especially in the last few years. We have seen that there has been large change in the contemporary law in terms of the society's changes. Amongst us, we have Honorable Mr. Justice Anand Venkatesh, a sitting judge of Madras High Court. Justice Anand Venkatesh has delivered judgments on the civil as well as on the criminal side, which are widely read, and so much so, while he was an advocate, he used to be appointed as an amicus curiae, which we all know that amicus curiae means friend of the court. That is where the court feels that there are certain requirements which requires of assistance of a lawyer in the right perspective, the issues in which the assistance has to be to the advent, because the court feels that where there is a proper assistance, then the law which are required is established. And therefore, when we see that there has been the contemporary trends which are being changed, and even though we are lucky enough that Justice Venkatesh is just like an amicus, he would be taking us to entire gamut of law which has been changed. He has also been a contact person for the Tamil Nadu State Judicial Academy. The judicial academies are playing a vital role pan-India because they give trainings to the judicial officers, etc., so that they are also well equipped with the latest changes in the law. He played a pivotal role in the consultation and drafting committee, especially of the Commercial Courts, Commercial Division and Commercial Appellate Division, High Courts Act 2015. The lawyers who are actively practicing know the importance of this act, which of late has created its own sphere within the judicial sides. So we welcome you all, and we are enamored with the presence of Justice Anand Venkatesh. As I earlier said, he is a judge of the Madras High Court, and we are obliged that he has accepted our invite and has agreed to disseminate the knowledge, which I'm quite sure after the session that everybody would be having a different perspective of law upon which he would be giving his insights. Thank you, sir. Over to you.
Yeah, thank you so much. Good evening to all who have assembled to be a part of this webinar series. I really thank the organizers for inviting me and making away this difficult situation. Virtually all of us are trying to somehow be positive throughout this difficult situation, and a result of which is the webinars that are being arranged across the country. And it used to be said that it's the difficult times which brings out the best in a human being. Humankind has been able to dominate or rule this world only because of its ability to come up, to find ways and means to overcome difficulties. And even though we are in very difficult times, the best of the humaneness is getting itself revealed through the number of people who have got themselves involved in feeding people, in providing shelter to people, so many things that are happening across the country. So that's a great sign of humaneness that is running across this country. So that's a great sign which we are seeing. The governments by themselves would not have been able to really handle the situation of feeding people. So there are lots of people who have pitched in and who are all part of the effort along with the government to help the have-nots. The other important development that has happened during this period is the webinars. This is something which we were not even contemplating 2 months back or 2.5 months back. It was never in our mind at all. But the moment the lockdown came, the video conferencing in courts will now become a future course of, even though a video conferencing, in my personal opinion, can never replace an open court hearing. But then I think it's not going to be the same, and there's going to be a lot of changes. And I'm sure that this video conferencing is going to be part of court hearings in future. So this webinar series that has been organized by several organizations, several associations, is really helping both the judges as well as the advocates to get themselves acclimatized with this virtual hearing. This virtual hearing platform, in fact, has enabled us to come in touch with people across the country. So it has the virtual hearing, the webinar series has virtually brought us all together, and we have no boundaries. And there are many from North who are addressing the webinar series that are being conducted in the South by certain associations. So the same is happening here. So it's a great feeling that it has really brought us all together, and it is a great opportunity for us to share the knowledge with each other. Sharing knowledge, according to me, is the biggest trait a person should possess. And therefore, now through these webinar series, we are able to really share knowledge with each other, which is a great positive aspect I am able to see. There was one reason why I had chosen this topic called as the contemporary trends in the march of law. Even though the court practices goes on our knowledge on the substantial law and substantive law and the procedural laws, at the end of the day, it becomes very important for us to be good with the law of precedence. That really helps us whenever we go and argue cases before the court. So updation of law as such becomes one of the most important aspect for every practice advocate and also for judges. And I always considered that the updation of law is one of the most important aspect of advocacy, which every advocate should develop. I was going through the biography of Fali S. Nariman, Senior Advocate, Supreme Court of India, in his book called as the Before Memory Fades. He was, when he talks about the advocacy, interestingly, he would have said that there is a melody called as case law diarrhea. That's the word which he uses, where he says that there is a trend among the junior advocates in the bar across the country who are attempting to accommodate facts of a case to the case laws. Meaning, because of the access to the case laws becoming more and more easier, where we are not sitting and searching book after book. A touch in the screen gets us all the case laws today. He says that this trend is now taking us, is now bringing a new melody, which is that there is an attempt to accommodate the facts of the case to the case laws. So what is happening is that the shirt which is already stitched is attempted to be accommodated for a body rather than a shirt to be stitched in line with the size of the body. So that's what is happening. When I say that, I only mean that you have to know the facts of the case and then apply the law to those facts. That is how it has to be. But because of easy accessibility of the case laws that is happening today, now it is working the other way around. So this has to be reversed, and it can be reversed only by creating awareness among the junior advocates, saying that at the end of the day, what is going to help you is only the facts. And in accordance with facts, you'll have to go and search for a law. The updation of law is a continuous process, which cannot be merely acquired by Googling. The other issue is that whenever somebody asks, immediately the junior advocates get into Googling. They Google, they go into India Kanun, they go into Manupatra, something like that, and they just get some case law and they load you with 25 judgments altogether. And if you carefully read those judgments, none of it will be relevant to the facts of the particular case. So therefore, the updation of law is not something which is being done now, which is Googling and trying out case laws. I think that the updation of law is the regular and continuous practice of updating yourselves by physically reading law weeklies every week, every fortnight, every month. That's the way in which the updation of law used to happen in the past. And I always believe that the same practice must continue. It's good that we are able to get access to the law easily, the case laws easily by getting into India Common, etc. But that's not the way to update the law. The best way, the correct way to update the law is that you will have to read journals on a regular basis, whether it's weekly or fortnightly or monthly. So that's the best way to do it. In fact, I was very interested when I was able to get access to one book. I do not know how many have seen this book. This book is called as the Miscellaneous Law Referencer. This is by the Universal Law Publishing. I do not know, because I have not seen this book anywhere else. This was a very, very interesting book, which is nothing but a compilation of the entire case laws that were maintained by Justice Chauhan, B.S. Chauhan, retired judge of the Honorable Supreme Court. So I was really interested in looking at this book, and I was luckily able to lay my hand to this book. It is very, very interesting to see the way in which this judge had maintained his diary on the case laws. And what he had done is that he had basically updated the judgment in the alphabetic order. And I was able to see that he had maintained judgments under 569 heads. 569 heads he has maintained this case laws in an alphabetic order. And in his preface to this book, he says, I quote, that on joining the legal profession, I started noting rulings on a particular legal issue in a diary in an alphabetic order. On elevation to the bench, I put relevant part of the judgments on a legal issue at one place and used it as a reservoir while writing the judgment. The text was revised periodically. It made judgment writing very convenient. Thus, this book is neither a piece of research work nor it deals with all problems under the statute. So basically, he says that this was an exercise which he had done right from his days when he was practicing, and the amount of assistance it has rendered him, both on account of the updation of law as well as it coming to be a needy help as and when he wanted to at the time of writing judgments as a judge of the High Court and thereafter before the Supreme Court. So this is a very, very interesting book, which if it is possible, I think all of you can get it, because you will get a lot of idea as to how you have to maintain the case law diary, which I call a case law diary. Today, You don't need to have a physical diary. It's possible that you can create files in your own iPad, in your own laptops, where you can keep reading and updating it on a regular basis. I have the locus standi to talk about it because this is what I have also been doing from the year 1991 onwards, immediately after I joined the law college. So if there is one thing which has really helped me in my career graph and making me reach to this position, I should say that updation of case law has always been one of the most important thing which has really helped me in not only understanding various subjects, various branches of law. That's the biggest advantage when you go through the journals. When you go through the journals, you don't confine yourself to a particular branch of law. The journals will contain a lot of branches of law being dealt with by different judges. So that's one other major advantage. So with this background, I thought that I can make this itself as a basis for my webinar talk today. So I suggested to the organizer that probably I'll try to address about the current trends in the march of law. See, broadly, today's talk I have tried to divide it into three. One is the important references that were made to the Supreme Court on important questions of law and that has been answered. Second is important references that have been made to the Supreme Court and the reference is pending. And I have also tried to collect some of the important judgments that have been rendered on varied topics by the Honorable Supreme Court. I hope that for the coming 1.5 hours, I will be able to substantially cover the references that have been answered and references that are pending today. And insofar as other important judgments are concerned, if time permits, I will get into it and try to somehow pick up certain important developments that have happened in some of the areas of law. So with this brief background, I will straight away get into the topic. First of all, I'll start with the Constitution of India. There are two very, very important developments that are taking place when it comes to challenges being made to the law made by the legislature. There are two concepts I would call, which is now gaining a lot of significance and about which there is a lot of discussion that is going on in the intellectual circles. One is the test of manifest arbitrariness, whether the manifest arbitrariness itself is a ground for the purpose of striking down a law. The second important concept that is doing its rounds is constitutional morality. This is the second thing which is again gaining ground, about which there is a lot of discussion in the circles. So first I will touch upon this test of manifest arbitrariness. So the question is, can the test of manifest arbitrariness per se, without linking it to any other test which we already have, can be a ground to strike down a legislation, is a very important question which is gaining significance now. As you all know, Article 14 of the Constitution of India, apart from equality of law, provides for one more important thing, which is equal protection of law. That is guaranteed under Article 14 of the Constitution of India. But the issue is, when this equal protection of law is guaranteed, the legislature or the government will have to necessarily classify and apply laws in accordance with the wants of the have-nots, in accordance with the wants of certain sections, which has to be treated separately. So when such classification happens, then when such classification happens, the result of such a classification is inequality. It automatically brings in inequality. So the very idea of classification is inequality. So how is that the courts were looking at it? How is that the law was developing on that? That that basic background is necessary for us to understand about the ground of manifest arbitrariness. So in order to attend to it came the concept of reasonable classification. And all of you must be aware about it. This reasonable classification founded on the intelligible differentia which have a nexus to the object sought to be achieved by the enactment. So this used to be the test that used to be applied whenever there is a classification made by the legislature. So therefore, the courts basically started testing the law, the enactments, wherever there is a classification which justifies such a classification by applying this formula of reasonable classification founded on the intelligible differentia with some nexus to the object sought to be achieved. This used to be traditionally one of the important tests which has evolved. And the next important test that used to be done by the courts is to see whether the object of the law itself is palpably discriminatory and whether thereby it violates Article 14 of the Constitution of India. So if the very object of the act is bad, is palpably illegal or discriminatory, then the court need not go through the exercise of seeing whether it's a reasonable classification. It pales to insignificance because the very object of the enactment itself is highly discriminatory. For this purpose, you can take note of the judgment of the Honorable Supreme Court in the BD Supply case, which is AR 1956 Supreme Court, page 479. I'll keep continuously giving the citations. Please note it down. So the important, this criteria of striking down legislation where the object of the law itself is palpably discriminatory was beautifully spoken by Justice Vivian Bose in BD Supply case, which is reported in AR 1956 Supreme Court, page 479. Then the law also used to be tested by seeing whether it is in line with the fundamental rights that are enshrined under Part 3 of the Constitution of India. So the courts will also see whether the effect of the operation of the law violates the rights guaranteed under Part 3 of the Constitution of India. This also used to be one of the important tests. I would want you to take note of the judgment in the Dalmia case, where all these things have been discussed and 6 principles have been evolved. These 6 principles have been enunciated in this particular judgment, which according to me is a milestone when it comes to testing a legislation. That is reported in AR 1958 Supreme Court, page 538. Then came the Rayappa case. The Rayappa case was in the year 1974. In Rayappa case, it's very important to keep in mind that what was under challenge was an administrative order. It is an order of transfer, and in Rayappa case, the subject matter of challenge was not a legislation. The subject matter of challenge was an administrative order of challenge. So in Rayappa's case, the Supreme Court applied the concept of arbitrariness, manifest arbitrariness per se, and had interfered into the order. So therefore, Supreme Court in Rayappa's case had deployed this manifest arbitrariness test and had interfered where arbitrariness per se was used to question the very order, administrative order, which was the subject matter. This Rayappa's case you can take note of in 1974 4 SEC, page number 3. 74 4 SEC, page number 3. This was subsequently followed by Ajay Hasia's case, which is 1981 1 SEC, page 782. These 2 judgments are seen as a landmark insofar as manifest arbitrariness is concerned. That is why I brought to your notice these 2 judgments. And please bear in mind that these 2 judgments did not have the subject matter of these 2 judgments was not a legislation; it was an order. So the next question is as the law developed, the question which came up in McDowell's case, which is reported in 1996 3 SEC page 709, is whether arbitrariness can be an independent ground of attack insofar as a legislation is concerned. In this judgment, the Honorable Supreme Court said that it cannot be. So therefore, virtually the Supreme Court said that whatever grounds has already been clearly enunciated by the earlier judgment will only apply, and you cannot test a legislation under the ground of manifest arbitrariness per se. That's what the Honorable Supreme Court said in this. Thereafter, nearly after 9 years, came the Subramanya Swamy case. That is in 2005, 2 SEC, page 317. 2005, 2 SEC, page 317. So what happened in this case was, if you look at paragraph number 6 of this judgment, you will find that this very question itself was referred for an authoritative pronouncement by a larger bench. What is that question? The question is whether manifest arbitrariness per se can be a ground for striking down a legislation. So this question itself was referred, and eventually the matter came up before the Constitution bench, which is reported in 2014, 8 SEC, page 682. 2014, 8 SEC, page 682. But unfortunately, what happened was that this question was not answered. It's very surprising that a reference was made and the bench was supposed to answer those references. But this question was not answered by the Constitution bench. And what the bench did was that it struck down Section 6 capital A of the Delhi Special Police Act on the ground that it is discriminatory. So the usual test was applied, and Section 6 capital A of the 6A of the Delhi Special Police Act was struck down. So therefore, there was a big opportunity for a Constitution bench to have gone into the issue, but it was not answered even though it was referred. Then what happened was, this concept of manifest arbitrariness was again resurrected thereafter by the Honorable Supreme Court in the year 2017 in Shaira Banu case, which is popularly called as the Triple Talaq case, which is reported in 2017, 9 SEC, page 1. This was resurrected, and the Supreme Court used this doctrine, used this concept. This was subsequently also used in Navtej Singh Johar case. You all know Section 377 IPC came to be challenged and it was struck down. And the Constitution bench in this judgment, again, they took note of this very ground called as a manifest arbitrariness. You will find it in 2018 10 SEC, page 1. 2018 10 SEC, page 1. Then one more judgment where it has been acted upon is the Nikesh Tarachand case. Nikesh Tarachand case. Even though there is a mention about manifest arbitrariness, you will find that in this judgment actually it was struck down under the regular grounds that are available under Article 14, and this was not the ground per se which was used for striking down. That judgment you will take note in 2018 2 SEC, page 193. So today, the most important question that is doing its rounds across the country, if you carefully read the journals, if you carefully listen to some of the jurists who talk about this manifest arbitrariness as a ground per se to strike down a legislation, is being very, very widely discussed, and there is no consistency, and there is a lot of debate that is going on as to whether it is a ground per se available to strike down a legislation, or even this manifest arbitrariness must again be read along with this classification test, the object being arbitrary test, or it is opposed to the Part 3 of the Constitution of India, etc. So therefore, there is a big debate that has been going on this, and a lot of articles have been written about it. So I thought that This is one very, very important concept that is slowly developing when it comes to testing the law made by the legislature by employing this concept of manifest arbitrariness. So therefore, my dear friends, you can keep a very careful eye on this issue, because this is going to develop even further, and it's possible that a lot of interpretation will come. After all, the Constitution is always seen to be a living document. So therefore, it's always important that there is some improvement, there is some new thinking that happens. This is a very new thinking that is going on across the country. So the second thing, insofar as the Constitution is concerned, is, as I said, is the concept of constitutional morality. Constitutional morality. This constitutional morality, basically, what is constitutional morality is something which cannot be easily defined at all. See, some people say, in fact, I read or heard somebody saying that it looks like it is a brooding omnipresence. That's how they say. They say that it's a brooding omnipresence, which is not very clear whether the constitutional morality per se, like our manifest arbitrariness, whether the constitutional morality per se can be a ground for striking down a legislature, is now gathering momentum slowly. So I give a small background on this also, so that you will understand what I am attempting to convey. See, law, as I said, is always tested on the anvil of a legislative competence, whether the legislature had the competence under the Constitution to come out with a law, or whether it is violating the fundamental rights as enshrined under Part 3 of the Constitution of India, or it is unreasonable and arbitrary classification test, about which I was also explaining to you. So therefore, these are all the traditional tests that have been well established, and it is the basis on this the courts keep testing the legislature, testing the law that has been enacted by the legislature. So, for the first time, this argument that a law can be tested on the basis that it goes against the very spirit, or it goes against the very soul of the Constitution, was done in the judgment in Kesavan Madhavan Menon case. So, Kesavan Madhavan Menon case was 1951, year 1951 Supreme Court, page 128. One of the most important ground that was raised was that the law was going against the very spirit or the soul of the Constitution. The Supreme Court said that there is nothing called as that. If you want to test it, you will have to test it within the parameters that are provided under the Constitution, and you cannot suddenly bring something called as the spirit or the soul. And the court is not to find out what that spirit or soul are. So it started there, and thereafter what happened was that the next judgment where this very concept came was in State of Bihar versus Kameshwar Singh case. Kameshwar Singh case is again the very next year itself, which is 1952, one Supreme Court reports, page 889. Again, this very issue came up before the Honorable Supreme Court. In fact, the Honorable Supreme Court, while pronouncing the judgment, while dealing with the judgment, had taken note of Dr. Ambedkar's speech on this very issue of this spirit or the soul of the Constitution, and it had extracted his speech in the Constituent Assembly, and ultimately the Supreme Court again rejected this ground of spirit or soul of the Constitution being made as a basis for testing a law made by the legislation. The next important case is the R.K. Garg case, which is popularly known as the bearer bonds case. As you all know, bearer bonds case was a case where at that point of time, the cash that was possessed was converted into bonds for persons who have evaded tax, etc. So one of the most important ground that was put forth in that case, where Mr. R.K. Garg, a senior advocate, appeared in person, he said that the very concept of this legislation offends the very morality, and it supports the dishonest persons who have avoided from paying tax. This was the ground that was projected before the Honorable Supreme Court. The Supreme Court rejected this ground again and said that the ground of morality as such must be pitched to something which is available in the Constitution. Morality is the concern of the lawmakers, and that cannot be a ground for the court to strike down legislation. So therefore, this very ground was projected in this case, in the bearer bonds case. It was again rejected by the Honorable Supreme Court. The next important case on this point is the Privy Purses case. Privy Purses case, as you all know, is a case where a sort of commitment was made to the kings of all these princely states which were acceded along with India, that they will be paid the Privy Purse. So what happened was that it was withdrawn. So therefore, that became a subject matter of challenge, and it went up before the Honorable Supreme Court, AR 1971, Supreme Court, page 530. See, one of the main grounds that was raised in this judgment was that the government had a moral commitment to the princely states, and they have been assured Privy Purse. And when you abolish it, it was argued by argued that it is you are going back on your own promise, which is immoral. That was one of the main grounds that was raised there. So this was again rejected by the Honorable Supreme Court, and the Honorable Supreme Court would have said that a moral obligation can never be converted into a legal obligation, and therefore they cannot be testing this law on the ground that it was a moral obligation on the part of the government, and since the government went back on it, the law per se becomes bad because it is immoral. The Honorable Supreme Court refused to do it. So this again came up as a subject matter. This very morality, constitutional morality, again became a subject matter in the famous breweries case, that is the Devon's Modern Brewery case, which is 2004 11 SCC page 26, where again this question of public morality was questioned, and the Honorable Supreme Court rejected it again. So this is how the law was going on, which started as the spirit or the soul of the Constitution, the constitutional morality. All these things were never accepted right from 1951 onwards up to 2004. If you see, there are, apart from the judgments which I have said now, there were several judgments where the Supreme Court was not willing to make this as a ground for knocking off a legislation. So the one detour, I would not even call it a detour, the one ground, one concept that was found by the Honorable Supreme Court is in Kesavananda Bharati's case, as you all know this case, where the famous doctrine of basic structure was deployed, and the Supreme Court was dealing with Article 368 of the Constitution of India, which gave the power of amending the Constitution, where the Supreme Court ultimately said that when you amend it, your amendment must not result in the very basic structure demolished. From where did they get this basic structure? They got this basic structure from the very Constitution itself. They were able to trace certain basic structures, not from anywhere outside. They were able to trace the basic structure from the Constitution, from the formation, from the body of the Constitution itself. They found that there were certain very, very important structure that is available in the Constitution, and by your amending power, you cannot demolish that structure. So therefore, I would not say that the basic structure doctrine is something akin to the morality or spirit or soul about which we are talking. That's not a brooding omnipresence. It is something which was available, which was culled out from the Constitution itself. So therefore, this basic structure cannot, the basic structure, I would say, if you want to call, is the only detour that was made by the Honorable Supreme Court, but not without a basis, but they found it in the very Constitution itself. So as time went by, slowly this constitutional morality became a sort of, started assuming prominence, when the courts started testing laws made by legislature. I would say that there are some 5 judgments where there is a reference to this constitutional morality. One is the Union of India versus the Delhi administration. As you all know, the powers of Delhi as a union territory, etc., became a big problem. And the Honorable Supreme Court had employed this, had taken use of this constitutional morality while deciding that case. That case is 2018 8 SEC, page 501. 2018 8 SEC, page 501. The next judgment where they have relied upon this concept is the Navteej Singh Johar case again, which dealt with homosexuality, etc. This judgment is in 2018 10 SEC, page number 1. The third judgment where they have placed reliance upon this concept of constitutional morality is the Joseph Shine case. This was, as you all know, is the one which tested that adultery. So this was the judgment in 2018 2 SEC, page 189. Then the fourth judgment is the defection cases in Karnataka. As you all know, this defection case where again they had employed this concept of constitutional morality, that is available in 2020 SEC online, page 55. 2020 SEC online, page 55. And the most important judgment where it is going to be applied or it is going to be tested is the Sabarimala case. As you all know, this Sabarimala case has now been, the review has been entertained, and you will find that the Honorable Supreme Court has formulated 7 questions that is going to be answered by the court in Kantaru Rajivaru case, that is 2020 SEC online, Supreme Court, page 158. 2020 SEC online, SC, page 158. So therefore, they have formulated 7 questions. One of the most important questions that has been referred now is whether constitutional morality by itself is a ground to test the legislation. So I hope that the Sabarimala case, for apart from several other important issues that are involved in it, this is going to be one of the most important issues that is going to be dealt with by the Honorable Supreme Court. And I hope that we are all going to get an answer, and we'll have to wait and see whether the law is really going to get settled. And we have to see whether the ground of constitutional morality by itself can be used, by itself can be employed or deployed for the purpose of striking down a legislation. So in the course of doing that, we are going to be explained as to what it means by constitutional morality. So I thought that this is one of the most important development that has taken place. So from constitution, now I'll move on to the other issues where the reference was made and it was answered by the Honorable Supreme Court. One of the most important questions which was referred was with regard to the doctrine of merger. The doctrine of merger. To put it simply, whether a review petition that is filed before the High Court after an SLP gets dismissed by the High Court is maintainable, or whether on the dismissal of the SLP by the Supreme Court, it merges along with the final order passed by the High Court, which became a subject matter of challenge before the Supreme Court. So basically what happened was Punyamat case, which is 2006 SEC, page 359, was holding the field. And this judgment had very categorically said that if the special leave has been rejected at the threshold itself, then whether you file the review petition before it or after the rejection, the review petition is maintainable, and the rejection of special leave at the threshold will not amount to the merger with the order passed by the High Court, and review is maintainable. That was the law that was in existence. But the correctness of this decision came to be referred to a larger bench. And in Kodai Distillery's case, which is reported in 2019, 4 SEC, page 376, the Honorable Supreme Court has very, very categorically stated that an order refusing special leave to appeal, whether it is a speaking order or a non-speaking order, will not amount to a merger at all. So at the stage when the special leave itself is dismissed, speaking by a speaking or a non-speaking order, it will not amount to a merger. The court said that if in case it is a speaking order, then it said that the findings that are recorded by the Supreme Court while rejecting the special leave by way of a speaking order will bind the parties thereto, and the court or the tribunal or any authority to which it goes subsequently, they will be bound to follow it as a judicial discipline. This was one of the most important things that came out of this judgment. Then, the Honorable Supreme Court also said that if once a leave is granted and thereafter the case gets dismissed, then the doctrine of merger will start operating. So the important test is whether leave was granted or not. The moment leave is granted and the appeal is entertained, irrespective of what the result is, irrespective of whether it is speaking order, non-speaking order, etc., it will amount to a merger along with the original order, and therefore there is no question of entertaining a review at this stage when a case in the Supreme Court reaches this stage. So the most important finding of the Honorable Supreme Court in this case was that once the order does not merge with the order of the High Court, which is the subject matter of challenge, then a review petition is maintainable, whether it was filed before the dismissal or after the dismissal. So, in short, the Honorable Supreme Court had virtually upheld the Kunya Ahmed case about which I was referring earlier. So, this is one very important reference that was answered by the Honorable Supreme Court. The other important issue that was referred to the Honorable Supreme Court is whether the woman can file a complaint from her place, from her parents' place, for a cruelty that has happened in her in-laws' place by her husband or her in-laws. Whether such a complaint can be maintained was one question which became vexed. So therefore, this question was taken up by the Honorable Supreme Court in Rupali Devi's case, which is 2019, 5 SEC, page 384. 2019, 5 SEC, page 384. So the important question that was referred to the Honorable Supreme Court is whether a woman who is forced to leave her matrimonial home on account of acts or conduct that constitutes cruelty can initiate a legal process within the jurisdiction of the court where she is forced to take shelter with her parents or other family members. This was the question which was referred. The Honorable Supreme Court had taken cue from section 179 of the Code of Criminal Procedure. As you all know, section 179 of the Code of Criminal Procedure is where it contemplates two things. One is the act done and the consequence that ensues out of that act. That provision will say that both those places will have jurisdiction. The courts in both those places will have jurisdiction. So the court took cue from that, and the court said that it was only due to the act committed by the husband or the in-laws in the matrimonial home, as a consequence of which the lady was forced to go to her parents' place or her relative's place. So therefore, the legal process can be initiated from the place to which she has been driven due to the cruelty meted out against her. So therefore, the Honorable Supreme Court said that a complaint under section 498 capital A of IPC is maintainable. So this is a very important development that had taken place, and the reference was accordingly answered by the Honorable Supreme Court. The next important issue, which was again causing a lot of confusion as between different high courts, was whether a suit for declaration can be filed on the ground of adverse possession. Declaration of title can be filed on the ground of adverse possession was one important question, which was really causing a lot of confusion as among different high courts. So what happened was that the Honorable Supreme Court in 2014, 1 SEC page 669 in Gurudwara Sahib case had held that a suit for declaration on the ground of adverse possession is not maintainable. It started from 2014 onward. Before that, there was no such thing, and suits used to be filed for declaration of title. So it started from there. Subsequently, it was followed in 2017, 9 SEC page 579. Thereafter, again, it was followed in 2018, 11 SEC page 449. So the law was in a flux, and there was a lot of discussion that was going on as among the intellectual legal circles, where they said that in the light of Article 65 of the Limitation Act being available, which recognized adverse possession, such a right being recognized by law cannot be knocked off by judgment of a court, and therefore the argument was that the court did not take into consideration such a right being recognized under Article 65 of the Limitation Act. So ultimately, this question came to be decided in Ravinder Kaur Grewal case, which is 2019 8 SEC page 729. The Honorable Supreme Court, in this case, after analyzing the entire law on the point, said that a right has been given under Article 65 of the Limitation Act to set up the plea of adverse possession, and it can be used both as a sword as well as a shield. What the Supreme Court earlier said was, you can only use it as a shield and you cannot use it as a sword, meaning you cannot use it for the purpose of getting a declaration that you have become the owner of the property. This was reversed, and the Honorable Supreme Court said that there is no bar in maintaining a suit of this nature. So this is one very, very important milestone, which virtually removed all the doubts with regard to the position of law. Thereby, the three judgments which I said all were overruled by the Honorable Supreme Court by virtue of answering this reference. The next important reference that happened was the word property that is used under section 102 of the Code of Criminal Procedure. See, section 102 of the Code of Criminal Procedure empowers the police in the course of investigation to attach, seize and sell properties. So the question was whether the word property that is used under section 102 of the Code of Criminal Procedure will include also immovable property. That was the most important question that was referred in Niveda property case, that is 2019 SEC Online, page 1247. 2019 SEC Online, page 1247. Here the Supreme Court was considering the effect of the word property under section 102, and it said that the word property under section 102 does not include an immovable property. It does not include an immovable property. It includes only a movable property, and the only clarification that was given by the Honorable Supreme Court was that it will not be a bar for the police to seize documents or papers pertaining to that immovable property. That was not rejected by the Honorable Supreme Court. So therefore, when it comes to an attachment under section 102 of the Code of Criminal Procedure, the court said that it does not include immovable property, but it will not bar the police from seizing documents, papers pertaining to the immovable property. This is one important difference you have to understand. So this is one important question which was again answered in this reference. The other important question that was referred to the Honorable Supreme Court was regarding this doctrine of mutuality. I'll give you a small background as to how it came up before the Honorable Supreme Court. See, if you look at Article 366, Clause 29, capital A, this defines, of the Constitution of India, this defines what is a tax on the sale or purchase of goods. So this definition is more an inclusive definition. And if you look at clauses E and F in the definition, that clause, those clauses were sought to be applied, and service tax was sought to be levied for the food and drink that is supplied to the members of a club. So the issue that was referred to the Honorable Supreme Court was, one, whether the doctrine of mutuality. What is doctrine of mutuality? Doctrine of mutuality is that, what is a club? A club is an association of members who run it for their own benefit. So therefore, there is a mutuality. In short, a club is run by the members for providing services for themselves. So that's the mutuality as between a club and a member. So the question that was referred is whether this doctrine of mutuality is still applicable to the incorporated clubs or any other club even after the 46th Amendment. What is this 46th Amendment? This 46th Amendment is the one which brought in Article 366(29) capital A. So whether this doctrine of mutuality will apply even after this amendment was brought into force in the Constitution. The second important question that was referred to the Honorable Supreme Court was whether the important decision that was holding the field, which is the Young Men Indian Association case reported in 1970, 1 SEC page 462, will still hold the field even after the 46th Amendment came into force. This was one other important judgment which was, and the court was also asked to look into the other 3 or 4 judgments where the court had remanded it back to the respective courts for the purpose of going afresh into this concept of doctrine of mutuality. So that was the second thing. And the third important issue that was referred to the Honorable Supreme Court was, after the 46th Amendment, which brought in this provision, whether the food and beverages that are supplied by the incorporated clubs to its members will constitute a sale, and thereby it is liable for a service tax. This was the main issue. So these were the questions that were referred to the Honorable Supreme Court. And the Honorable Supreme Court, I would request the young members of the bar to read this judgment in the state of West Bengal versus Calcutta Club. In the Honorable Supreme Court in this judgment ultimately said that the doctrine of mutuality continues to be applicable to incorporated and unincorporated clubs, to where the clubs are providing services to its members. So therefore, it does not make any change even after the coming into force of section 366 clause 29 capital A of the Constitution of India. Second, the Honorable Supreme Court said that the judgment in the Young Men's India's case, which established this concept of mutuality, continues to hold the field even after the 46th Amendment. And the Honorable Supreme Court very categorically said that Article 366 clause 29 capital A will have no application to members clubs. So therefore, this service of food, beverages, etc., or any other thing as between the members of the club cannot be construed as a sale. This is one of the very important judgments about which you have to take note of. The next important question that was referred to the Honorable Supreme Court was the institutional preference that was given to the postgraduate admissions. As you know, NEET, the scheme called as NEET, came into force, whereby all admissions pertaining to medical colleges and dental colleges will be based only on the marks that are secured by entering into, by taking this NEET exam. So the important question that was referred to the Honorable Supreme Court was whether even after this NEET came into force, the institutional preference, which is 50% of the institution, the institution by itself can fill up 50% of its seats. So that was the position, and the Honorable Supreme Court, by repeated judgments, has already held that this is permissible. So therefore, the question was whether those judgments of the Supreme Court will continue and this institutional preference can continue even after the NEET came into force. The Honorable Supreme Court in Yatin Kumar Jesubai Patel case, reported in 2019 10 SEC page 1, categorically held that such a regulation providing 50% institutional preference to the concerned institution to fill up the seats in the PG category, in the PG medical course, will continue, and it cannot be held to be ultra-virus to Section 10D of the Medical Council of India Act, MCA Act. So the Honorable Supreme Court said that this institutional preference will continue, and the only clarification that was made by the Honorable Supreme Court was that even in cases of such institutional preference, the admissions in the postgraduate courses shall be given only on the basis of merits and the marks that are obtained in the NEET examination. That's a very, very important thing. Therefore, even though this 50% institutional preference was sustained even after the NEET came into force, the Honorable Supreme Court made it clear that this preference will have to be filled, that 50% seats in PG medical course will have to be filled only based on merits and based on the marks obtained in the NEET examination. So this is one important question that was answered by the Honorable Supreme Court. The next very important reference that was made to the Honorable Supreme Court is whether the purchaser of a property who has purchased the property after the issuance of the notification under Section 4 of the Land Acquisition Act 1894 is entitled to invoke the provisions contained in Section 24 of the Right to Fair Compensation Act, was a very important question that was placed before the Honorable Supreme Court. Because what was happening was that, as you all know, Section 24 of the Act was, of the new Act 2013, was providing for declaring such acquisition to have abated under certain circumstances. So what happened was persons who had purchased the property started approaching the court saying that it has abated under Section 24. So therefore, you have the petitions filed by them have to be entertained. So this became a big confusion, which virtually was resulting in reviving a right which they did not have. So Honorable Supreme Court went into this question in detail and categorically held that a purchase that is made after the Section 4 notification is void as against the state. Such a sale is declared to be void as against the state. Therefore, it said that there is no transfer in the eye of law. And if there is absolutely no transfer in the eye of law, and if that sale is held to be void, then the subsequent purchaser cannot be allowed to invoke the provisions of Section 24 of the 2013 Act. And so Honorable Supreme Court said that that sale transaction did not clothe him with any title. So this is an important judgment in Shiv Kumar case, which is reported in 2019 10 SEC, page 229. The next important judgment is the judgment of the Constitution Bench. In Supreme Court of India was a Subhash Chandra Agarwal. This name all of you must be knowing. He is the person who is championing this right to information. And this is a very, very important judgment which was referred to the Constitution Bench. The issue that was referred was whether the office of the Chief Justice of India will also come under the RTI Act. There was a lot of issues that were going on, a lot of disputes that were going on. There was no clarity on the issue. So therefore, this question by itself was referred to the Constitution Bench. In Supreme Court of India versus Subhash Chandra Agarwal, you can go through this judgment in 2019, SEC Online, Supreme Court, page 1459. The Honorable Supreme Court unanimously held that the Supreme Court of India comes within the term public authority which will also include the office of the Chief Justice of India and the other judges in view of Article 124 of the Constitution of India. So therefore, it said that it comes within the term public authority, and the Chief Justice and the other judges together form and constitute this public authority, which is called as the Supreme Court of India. Therefore, the Honorable Supreme Court said that it will apply, the RTI Act will apply. But the Honorable Supreme Court had given certain guidelines, some 6 guidelines to be followed at the time of processing this application, which is seeking for the information under the RTI Act. 7 guidelines were given by the Honorable Supreme Court. So this is one of the most important judgments that was rendered by the Constitution bench when this question was referred. Then the very, very important question that got referred to the Honorable Supreme Court was the issue with regard to whether a meritorious student who wants to get into the medical profession or a dental profession and who had worked out his right on time and who had pursued his remedy expeditiously, whether he can be deprived of a seat only because the cutoff date of 30th of September had crossed. I'll have to give you a small introduction here. The Honorable Supreme Court has already held that insofar as filling up of the medical seats are concerned, it has to be done on or before the 30th. It has to be finalized on or before the 30th of September of every year. After 30th of September, there is no question of filling even a single seat. That is how the law was. So there were, but repeatedly there were issues where a person, a boy or a girl has been deprived of a seat to which they are entitled to, and they had approached the court immediately. They were pursuing their remedy expeditiously without any delay. But by the time the court takes up the case and decides the case, this cutoff of 30th September crosses. So what happens is that ultimately, even though the court finds that he is entitled for that seat, the court's hands were tied because of this 30th September being fixed as the cutoff date for the purpose of filling up the medical seats. So this became a very big problem across the country. So the Supreme Court had an occasion to deal with this. This was referred in Krishna Sarada versus State of Andhra Pradesh, which is reported in 2019 SEC Online, Supreme Court, page 1609. The Honorable Supreme Court took up this reference to decide this very, very important issue pertaining to the students. And the Honorable Supreme Court said that the concerned court which deals with the issue will have to give top priority to cases of such nature, and all attempts will have to be made to dispose of the petition one way or the other by the cutoff date of 30th September. That was number 1. Number 2, the Honorable Supreme Court said that under exceptional circumstances where the fault cannot be attributed to the candidate, and the candidate was expeditiously, properly following up with his remedy, and the fault was only as against the authorities for breach of rules which resulted in depriving him a seat, then the Honorable Supreme Court said that in rarest of rare cases, this rarest of rare cases is something which must be ringing your mind. This was something used by the Honorable Supreme Court when it came to a death sentence. So they used that word here, in rarest of rare cases and in exceptional circumstances. The Honorable Supreme Court said that such a candidate cannot be deprived of a seat in medical college. And even if it crosses 30th of September, the court is entitled to direct the admission of such a boy in the college. And it said that under no circumstances such an order can be passed after the expiry of 1 month, meaning such an exception can be created only up to the 30th of October. As I said, the the time limit fixed was 30th of September. In these exceptional cases where there was absolutely no fault attributable to the candidate, where it crosses 30th of September, the court said that you can direct an additional seat to be created and the boy or the girl to be accommodated in the seat. And even this exercise can be done only up to the 30th of October during the concerned year. So the Supreme Court said that a meritorious candidate should not be deprived of this remedy being given by the court. So the court also said that if the deprivation of the seat had resulted in some other candidate who is last in that list having got the seat and who who is placed much below the candidate who was entitled for such a seat, then the Supreme Court said issue notice to that candidate and it is possible to cancel the admission that was given to that candidate also for the purpose of accommodating the meritorious candidate. That's a very, very important development that happened. Supreme Court did not stop there. The Honorable Supreme Court said that if in case you are not able to give this relief by the 30th of October, then what happens? If by 30th of October you are not able to give it, because that was the timeline that was fixed by the Honorable Supreme Court. It said that the court can mold the relief and it can direct the candidate to be taken in to the course in the next academic year. And the Honorable Supreme Court said that if the deprivation of seat had occurred due to the fault of the management, then this seat must be adjusted towards the management quota of the next year, and the management quota seats must be less by one seat. And that less by one seat is the seat which has to be given to this meritorious candidate who can be permitted to join in the next academic year. So therefore, Honorable Supreme Court ensured that this candidate who is meritorious should not be deprived of his seat at any rate. This is a very, very, very important development because a lot of candidates who had the merit were being deprived of a seat just because it crosses 30th of September. And the Honorable Supreme Court finally said that if a candidate is not able to be accommodated by 30th of October and he is only given it the next year, then at that point of time, for the loss of the time, the candidate can also be given compensation, which is an additional relief that can be given to the concerned candidate. This, according to me, is a very, very important step that was taken by the Honorable Supreme Court. And by doing this, the Honorable Supreme Court had overruled the earlier judgment in 2014, Chandigarh administration case, which is 2014, 10 SEC, page 521. 2014, 10 SEC, page 521. So it was clarified that these directions will pertain only to the admission in MBBS course. Keep this in your mind. It pertains only to the admissions in MBBS course, and they did not deal with the post-graduation medical course. This is very important to understand. Then the next issue that was placed before the Honorable Supreme Court was, this is a very, very ticklish issue that was troubling a lot of high courts. So therefore, this question was referred to the Honorable Supreme Court. And the question was whether the persons who are governed under the Persons with Disabilities Act, which we call as the PWD Act, can be given a reservation in promotion. It's a very important question that was referred to the Honorable Supreme Court. And this was answered by the Honorable Supreme Court in Siddha Raju case, which is 2020 SEC Online, Supreme Court, page 45. 2020 SEC Online, Supreme Court, page 45. The Honorable Supreme Court went into the whole concept of section 32 and 33 of this PWD Act. And the Honorable Supreme Court was placing reference on Indira Sawhney's case, because Indira Sawhney's case, as you all know, is the one which said that there cannot be reservation in promotion. That was the judgment which said that there cannot be reservation in promotion. And the Honorable Supreme Court said that Indira Sawhney's judgment will have no application when it comes to persons with disabilities. So the Honorable Supreme Court read the section, interpreted section 32 and 33 of that act, and it said that the promotional post in question, if it is identified as a suitable post for the person suffering disability, the promotional post, if it is identified to be a suitable post for the purpose of promoting a person to that, then this 3% reservation for persons with disability must be provided, is what the Honorable Supreme Court said. Honorable Supreme Court said that this is not a reservation in promotion, but this is as a result of you complying with section 32 and 33 of the Act, where you have already identified the post to be suitable to be filled up with persons suffering from disability. Therefore, it said that you can fill up 3% of the post with persons suffering with the disability in those promotional posts also. This, according to me, is a very important milestone that went in favor of persons who are suffering with disabilities. So basically, by doing this, the Supreme Court said that when you undertake this exercise, then you have to do it in line, in tune with the earlier judgments, 2 judgments of the Honorable Supreme Court in 2015 9 scale page 611, and the other judgment is 2016 13 SEC page 153. I'm sorry, I'm barging you with judgment after judgment, but I thought it's very important that you take note of all this. Only then you will be understanding the significance of all these references that were answered by the Honorable Supreme Court. So these 2 judgments were directed to be taken into account for the purpose of filling up that promotional post. Then, one other important issue that was referred to the Honorable Supreme Court was whether the protection that is granted to a person under section 438 of the Code of Criminal Procedure, which you all know is anticipatory bail, whether it should be limited only to the period, only for a particular period, to enable the person to surrender before the trial court and thereafter seek for a regular bail. This was one question that was referred. The second question that was referred was whether the life of an anticipatory bail will automatically come to an end at the time and stage when the accused is summoned by the court. When is the accused summoned by the court? The accused is summoned by the court after the final report is filed and it is taken cognizance by the court, and thereafter summons are issued. The question is whether immediately on the summon being issued, the anticipatory bail comes to an end, and thereafter the accused will have to come surrender and get a regular bail. These 2 questions were basically doing its rounds, and this was as a result of various judgments of the Honorable Supreme Court, starting from Siddharam Sitangappa case. There are a lot of judgments which were overruled in this judgment, because all those judgments were given contrary views with regard to, by giving an impression as if an anticipatory bail is limited to a particular period. You can go through these judgments in 2011, 6 SEC page 189, then to 1996, 1 SEC page 667, then 2004, 7 SEC page 558, then 2010, 1 SEC page 679. See, in all these judgments, you will find that the Honorable Supreme Court had laid down such restrictive conditions, where the Supreme Court had said that restrictive conditions can be imposed, or the grant of anticipatory bail can be limited. These 2 things would have come out of all these judgments. All this was overruled by the Honorable Supreme Court in this judgment. And the Honorable Supreme Court said that a protection granted to a person under section 438 of the Code of Criminal Procedure should not invariably be limited for a fixed period. That's the most important finding that came out of this judgment. And it said that it should inure in favor of the accused without any restriction of time. The only protection that the Honorable Supreme Court said that while granting such an anticipatory bail, you can impose conditions as contemplated under 437(3), read with section 438(2), of the Code of Criminal Procedure. So you can take into account all those conditions that are enumerated therein, and you can impose it as a condition when you grant an anticipatory bail. So it said that it is possible for the court to impose appropriate conditions while granting the anticipatory bail, and it should not be limited for a particular period. The second important question that was answered by the Honorable Supreme Court is that the duration of the anticipatory bail will not come to an end, at any time or at any stage, and even after the summons is issued to the accused person and the charges are framed, it will continue till the end of the trial. This is very important because there was a confusion also in this area. Supreme Court clarified that this protection that has been given will endure till the end of the trial. So it's very important that this judgment ultimately had come out with two things. One is that you cannot lay down such very restrictive conditions or terms which will virtually limit the very grant of the anticipatory bail itself, and the grant of anticipatory bail under normal circumstances should not be confined to any time limit. So this judgment is very, very important for those who are practicing on the criminal side. This clarification has come, and all the earlier judgments were overruled. Whatever I was referring to was overruled. The other important judgment that came up before the Honorable Supreme Court, over which there was a lot of discussion, was the judgment of the Constitution Bench on Section 24. Earlier in my talk, I was referring to the right of a subsequent purchaser after a 4-1 notification, whether he is entitled to take advantage of the provisions under Section 24, which talks about lapse of the very acquisition proceedings itself. I refer to the 24. The most important question that was referred to the Constitution Bench in Indore Development Authority versus Manohar Lal. This is in 2020 SEC Online, Supreme Court, page 287. Excuse me. 2020 SEC Online, Supreme Court, page 287. This is one of the most important judgments which gave rise to a lot of debate across the legal circles. And as you all know, Section 24 of the 2013 Act, which is called as the Right to Fair Compensation, Transparency in Land Acquisition, etc., Act of 2013, it talks about when the acquisition proceedings start, which says when an acquisition proceedings is started under the 1894 Act, Land Acquisition Act, when it will lapse. It gives the condition A. It says where an award has been passed under Section 11 of that old Act and the 5 years period has elapsed and the physical possession has not been taken. This is one circumstance. Second circumstance is where the compensation has not been paid. So this physical possession not being taken, compensation not being paid, was a subject matter of various judgments of different high courts and also the Honorable Supreme Court. And the judgment of the Honorable Supreme Court, it was felt that it gave rise to a lot of lands which were liable to be liable to come out of the net of land acquisition, and the governments were finding it difficult to handle the situation. So therefore, in order to get to an end the controversy, the very questions that were referred to the Constitution Bench were: one, what is the meaning of this expression called as paid? I said that if compensation is not paid, so what is the meaning of this expression paid under Section 24 of this 2013 Act? Became one important question. Then, while dealing with that question, the Honorable Supreme Court was asked to answer whether non-deposit of the compensation in the court compensation that was supposed to be given to the owner of the property, not deposited in the court, will be construed as refusal to pay the compensation. And whether the persons who have refused to take the compensation when it was tendered to them earlier can take advantage of their own conduct and say that I have not been paid the compensation, therefore the acquisition has lapsed, therefore the land gets revested to him. Apart from that, one other important question that was answered, that was referred to the Honorable Supreme Court Constitution Bench was, what is the mode of taking possession? What does it mean to say possession has been taken? Because it becomes a very important issue if it is a vacant land. If it is a vacant land, how do you take possession? If it is a building and a property, it's always possible to physically take possession of it. In most of these cases, these are barren vacant lands. So therefore, the Supreme Court was asked to answer or give the explanation as to what it means by taking possession. What is the mode of taking possession under the Land Acquisition Act? Then the other important question that was referred is whether the period that is covered by an interim order by any high court, any court, should be excluded for the purpose of calculating this 5-year period, which is spoken to under Section 24. And the last question that was referred is whether Section 24 will revive the barred or the stale claims. I said that the barred or stale claims are those claims which were made even when the acquisition took place and it was all ordered. Thereafter, by taking advantage of this 5-year, whether you can revive such a right again. So these are the important questions that were referred to the Honorable Supreme Court. The Honorable Supreme Court basically answered these questions as follows. Insofar as payment is concerned, the Honorable Supreme Court said that the word expression payment under 24(2) does not include depositing the compensation in the court. So therefore, if it had been tendered and if you have not received it, then you cannot take advantage of your own conduct and say that you have not been paid. So it is not necessary that this deposit should have been made in the court for the purpose of satisfying Section 24(2). So it said that the consequence of a non-deposit is a non-deposit that is provided under Section 24(2), proviso to Section 24(2), does not cover or include a deposit in the court. Then it said that non-deposit of a compensation in the court will not result in the lapse of the land acquisition proceedings. It will not lapse. The land acquisition proceedings will not lapse. Then the Honorable Supreme Court went into the issue of whether the persons who had not been, who have refused. It said that the landowners who have refused to accept compensation or who have sought for a reference for a higher compensation, they cannot claim the relief given by the proviso to Section 24(2), and they will not be entitled to employ that provision. Insofar as possession is concerned, the Honorable Supreme Court said that it is the mode of possession is by way of drawing an inquest report or a memorandum. That suffices taking of possession is what the Honorable Supreme Court said. And the Honorable Supreme Court, for coming to such a conclusion, relied upon one judgment of the Honorable Supreme Court in Banda Development Authority case, which is 2011, 5 SEC, page 394. This judgment was approved insofar as mode of taking possession under the land acquisition proceedings. Then the Honorable Supreme Court said that Section 24(2) does not give rise to any new cause of action, and therefore the legality of the concluded proceedings under the land acquisition which has already taken place will never revive, and the stale and the proceedings which have already become stale can never be reopened using this Section 20 proviso to Section 24(2). This was one of the most important judgments rendered by the Constitution Bench of the Honorable Supreme Court, which gave a clarity with regard to proviso to Section 24(2), and this virtually had now settled the law on the issue with regard to the effect of proviso to Section 24(2) of the 2013 Act. Then, moving to the next issue, one of the important issues that were referred to the Constitution bench in Christian Medical College, Vellore versus Union of India. Christian Medical College, Vellore versus Union of India. This judgment was rendered on 29/4/2020, just 2 months back. So one of the most important question that was referred to the Constitution bench was whether imposition of the NEET on the minority aided or unaided institution is a violation of Articles 19(1)(g), 25, 26, 29 and 30 of the Constitution of India. This is one important question that was referred to the Constitution bench. The Constitution bench, after going through the entire scope, basically said that it does not in any way violate the rights of the minority institutions, and the Supreme Court specifically placed reliance upon Article 47 and Article 51(a)(j), 51 capital A clause J of the Constitution of India, and it said that this NEET examination has been brought in only to ensure excellence, only to ensure that the objective of excellence that is considered to be a fundamental duty under the Constitution of India is being upheld. So therefore, it said that this reasonable regulatory measures which actually increases the quality of the education can never be said to be interfering with the minority rights under Article 30 of the Constitution of India, and therefore the Supreme Court had rejected the claim made by the minority aided, unaided institutions, which raised the ground that imposition of a NEET is a interference into their minority rights. Then the other important issue that was decided by the Honorable Supreme Court, or which was answered as a reference, was whether the applicability of the Securitization Act 2002 will also apply to cooperative banks. This was again a vexed question that was continuing, whether cooperative banks can also be brought within the term of a bank, and whether the securitization route can be adopted for the purpose of recovering the dues. So this became a very important question in Pandurang Ganpati Chagla case. This was decided on 5/5/2020. I don't know whether it has been reported, but this was decided on 5/5/2020, just this month. And the Honorable Supreme Court said that the cooperative society registered both under the state legislation and also these multi-state level cooperative societies, for all those societies which has a bank, cooperative bank, which is involved in the activity of banking, will be covered under this act. So therefore, they were also held to be coming under the Securitization Act, and the Honorable Supreme Court answered the reference saying that it will apply. This Securitization Act can be applied even by cooperative banks. This is a very, very important decision of the Honorable Supreme Court. And one of the most important decisions which was again doing its rounds all over was with regard to the quantity. As you all know, under the NDPS Act, it deals with two quantities with regard to psychotropic substances and also the narcotic drugs, where it is a small quantity or a commercial quantity. Of course, there is something called as in-between quantity, where it falls in between these two. So this small quantity and the commercial quantity will have a lot of significance when it comes to punishment. It will have a lot of significance while deciding the bail, grant of bail. So therefore, there was a lot of confusion on this by virtue of the decision of the Honorable Supreme Court in Michael Rath's case. In Michael Rath's case, the Honorable Supreme Court had said that the neutral substances that gets mixed with these narcotic drugs or psychotropic substances must be removed, and the actual narcotic drugs or the psychotropic substances must be weighed, and only thereafter you will have to find based on that weight whether it is a small quantity or an in-between quantity or a commercial quantity. The controversy was that there is already a table under the NDPS Act, as all of you must be knowing. There is a table which is dealing with a number of heads, which will cite the concerned psychotropic substance or the narcotic drug, and it will say which quantity, up to which quantity it is small quantity, and which quantity is the commercial quantity. So this is in entry 239 in that table deals with mixture of neutral materials along with these narcotic drugs and psychotropic substances. So it was already taken care of under the table annexed along with the Act. But the issue was, when the Honorable Supreme Court decided Michael Raj's case, it did not take note of this entry 239 and the notification of the government on 19/10/2001. So there was a lot of controversy revolving around it, and ultimately the issue was referred to the bench. And in Hira Singh versus the Union of India, and the judgment was rendered last month on 22/4/2020, where the Honorable Supreme Court had taken up 2 or 3 issues to be decided. So Honorable Supreme Court, first question to be decided was whether the judgment in Michael Raj requires reconsideration, since it omitted to take note of entry 239. Then the second question that was referred or was answered by the Honorable Supreme Court was that whether the NDPS Act envisages the mixture of narcotic drug and seized substances along with the neutral materials, and whether the content that is specified will have any impact on the determination of the small quantity or the commercial quantity, and then whether Section 21 of the NDPS Act is a standalone provision or it is intrinsically related to the other provisions which deals with the manufactured drug and preparation containing a manufactured drug. This is a very, very important issue that was taken up by the Honorable Supreme Court. Section 21 of the Act deals with or provides for punishment for the contravention in relation to manufactured drugs and the preparation depending upon small quantity, in between quantity, or the commercial quantity. So the Honorable Supreme Court basically held that Michael Raj judgment is 2008 5 SEC page 161. 2008 5 SEC page 161. Honorable Supreme Court said that Michael Raj judgment is no more a good law. Virtually it has been overruled now, since the court found that the earlier judgment did not take into account this entry number 239, which was already available in the Act. Then the Honorable Supreme Court also said that in case of seizure of a mixture, I said that neutral substances getting mixed with the narcotic drugs or psychotropic substances. So in case of seizure of a mixture of narcotic drugs or psychotropic substances with one or more neutral substances, then the quantity of the neutral substances is not to be excluded, and it can be taken into consideration along with the actual content by weighing the offending drug. Very important. It said that it can be taken into consideration along with the offending drug while determining the quantity, meaning small quantity or the commercial quantity of the narcotic drug. And the Honorable Supreme Court also held that Section 21 of the NDPS Act is not a standalone provision, and it must be construed along with other provisions in the statute, including the notification of the year 2009 and 2001. So by virtue of this judgment, now what happens is that when it comes to weighing and determining whether it is a small quantity or a commercial quantity, then the mixture of neutral substances does not really matter. So we have to see how this judgment is going to be put to practice and what impact it is going to have on the courts which are deciding cases under the NDPS Act. So with this, I will conclude the references that have been answered. I'll quickly move on to the references which are currently pending before the Honorable Supreme Court. The references that are pending before the Honorable Supreme Court is, one reference is with regard to the scope of Section 13 of the Prevention of Corruption Act. See, Section 13 of the Prevention of Corruption Act, what happens is that the issue is that in the absence of an evidence of the complainant, whether it is direct or primary, who had initiated or set the law in motion, in the absence of his evidence, with regard to demand of illegal gratification, the question is whether it is permissible for the court to draw inference with regard to the culpability or the guilt of the accused person or the public servant under Section 7 and Section 13(1)(d), read with Section 13(2) of the Prevention of Corruption Act, based on the other evidence that is adduced by the prosecution. Basically, the earlier judgment said that it cannot be done. That judgment is Satyanarayana Murthy case, reported in 2015, 10 SEC, page 152. This judgment has been doubted by the later bench, and it has now been referred, and you will find that reference order in Neeraj Datta case in 2019, 14 SEC, page 311. 2019, 14 SEC, page 311. The next important question that has been referred and where it is pending an answer is with regard again to the scope of Section 319 of CRPC. This 319 of CRPC for some reason goes before a constitution bench again and again. The earlier constitution bench which settled the law under Section 319 of CRPC, as you all know, is in Hardeep Singh case, where a constitution bench had clearly explained the scope in 2014, 3 SEC, page 92. But however, now it has again been referred to a constitution bench in Sukhpal Singh Kaida case in 2019, 6 SEC, page 638. And the question that has been referred is something which was not dealt with by the earlier constitution bench. The question that has been referred is whether the trial court has the power under Section 319 of the Code of Criminal Procedure to summon an additional accused where the trial with respect to all the other co-accused has ended and the judgment of conviction has also been rendered. So what happens is that the judgment of conviction is rendered, and on the same day an order is passed adding somebody as an accused person. Whether that will come after the completion of the proceedings with regard to the co-accused persons. The second issue that has been referred to the constitution bench is whether the trial court has the power under Section 319 of CRPC to summon an additional accused when the trial in respect of certain other absconding accused persons is pending, is going on, or it is pending. So these two, and apart from that, the third question that has been referred is what are the guidelines to be given? So basically the court is again going to get into the earlier judgment in Hardeep Singh case and give the fresh guidelines also. So this is a reference which is again pending. Then the next important issue that has been referred is the one which the entire country is looking for, which is the scope of Section 65B of the Evidence Act on the electronic evidence. For some reason, there is no clear pronouncement of law when it comes to this electronic evidence for the last 20 years. And unfortunately, every evidence that now comes up before a court in every other case will involve an electronic evidence. As you all know, it all started with Sandhu's case, which is 2005, 11 SEC, page 600. In Sandhu's case, basically the court said that you can either prove the electronic evidence as a secondary evidence under Section 65, or if you want to bring it under 65B, then you may have to produce a certificate under 65B4. So if you don't want to bring it under 65B, then it is possible to bring in an electronic evidence by taking note of section 65 or under 65 of the Evidence Act as a secondary evidence. It started that way in Sandhu's case. Then Anwar's case came. In Anwar's case, a 3-member bench again reconsidered the whole thing. That is in 2014, 10 SEC, page 473. In this case, the Honorable Supreme Court larger bench said that 65B is mandatory and it is a special provision. There is no question of applying section 63 and 65 of the Evidence Act, which is overwhelmed by 65B, which is specific or special insofar as an electronic evidence is concerned. Controversy did not stop there. Then came the Sonu's case. Sonu's case is 2017, 8 SEC, page 570. In Sonu's case, it was decided by a 2-member bench. The 2-member bench took into consideration the judgment of the 3-member bench in Anwar, but it said that the objection with regard to the admissibility of a secondary evidence must be raised the moment it is tendered, and it only pertains to the mode of proof, not the admissibility. It looked something which is contrary to the earlier judgment in the Anwar case. So Sonu's case started coming. What is important is that between Sandhu and Anwar, it was a near 9-year gap. And what happened was, after the Anwar case, wherever 65B was not satisfied, in heinous crimes, people have come out because the court said that you cannot take it as an evidence. After the Anwar case in 2014, then came the Sonu's case in 2017, 8 SEC. Again, the law got sort of changed. Then came the Shafi Muhammad case, which is in 2018, 2 SEC, page 801. In Shafi Muhammad case, now the Honorable Supreme Court said that a certificate need not be produced under 65B4 when the instrument from which when the instrument from which the secondary evidence is derived, the electronic evidence is derived, is not in the custody, or the device from which the electronic document was generated who is not in the custody of the person, and therefore in such case a certificate need not be produced. So this has been going back and forth, and ultimately now it is pending reference, and I am told that the arguments have already started. This reference order you can find in Arjun Pandit Rao Otkar case. That is in 2019, SEC Online, Supreme Court, page 1553. Page 1553. And of course, I said that when I was talking about constitutional morality, the Sabarimala case is again pending before the bench, and it is eagerly awaited as to what is going to come out of it. My dear friends, I have a full bunch of judgments with regard to the important decisions rendered by the Honorable Supreme Court during 2019 and 20 in various subjects. If I start that now, I think I'll go for another 2.5 hours. So on a Saturday evening, I do not want to really take your time on that. But God willing, if in future there is some occasion for me to get back, then probably I'll take it as a separate topic, and I would love to exchange my ideas on this. So with this, I think that the junior members of the bar will be really benefited, since I have virtually gone across various fields of law, and I have told you the important references that have been answered and important references which are yet to be answered by the Honorable Supreme Court. Thank you so much for the opportunity.
Thank you. In fact, when we had invited you on this platform, and you also know that the topic was very different, thereafter we decided that contemporary laws and the march of the changing trends. Then, heart within heart, when the team of Beyond Law was deciding, they just thought that it would be just a sneak view into all this. But we never realized that it will be an entire gamut. It's more like everything what could have been conceived under the sun, from the law, how it conceived and how there has been marching. March, as we said that once we were discussing, I was discussing with your good self that in the topic we should have a march, colon of the march, because we said that march should be distinguishable. Let's assume that people do not connect it with the march of the lockdown period. But I can really say on behalf of Beyond Law CLC and the participants, and I am also seeing from the messages being received on the chat box of the session, that everybody has in fact liked it, and from them it can it's a good indication that yes, we can look forward for a second session. And the way you were presenting entire things, another thing which at least which was going around in my mind was that while we were reading the different issues like in Beyond Law, in this Bar and Bench Live Law, they give a monthly wrap up of what are the latest judgments today. On our platform today, we have a young but budding lawyer, Amit George. His article has just been published on Bar and Bench today itself. He has given the bird eye view of what has happened in Delhi High Court. But for your good self, you have given the judgments of good last 3-4 years where there has been march. I was just jotting it down because the spectrum of issues which you have done, I thought that there was very less which has been, I don't think any issue has been there. You have discussed on constitution, you have discussed on land laws on section 24, the securitization, bail, then NDPS Act, all issues have been discussed in a manner, and it was a seamless effort. But one could always understand, it looks, as we say that once you watch a match, it looks very easy, or anybody arguing in the court, it looks as if the effort is very seamless. And it's very easy. But since majority of the persons who are on the platform are young lawyers and the lawyers or the students, it looks very convenient. But actually, there is a lot of practice and effort and hard work which goes behind it. So since we are running short of time, few issues I will be taking across the platform which I have received on the WhatsApp or on the chat box. Number one, how do you assimilate so much facts in so many judgments, despite the fact that as a lawyer, I know that any judge invariably gets a fixed roster for a particular few months, at least in Punjab and Haryana High Court where I am practicing, is there. Then how do you, despite the fact invariably what happens is as a lawyer also the type of cases what he gets, invariably he starts practicing on that. And he doesn't touch the latest judgment. Let's assume there is a journal also, it's a common judgment, let's assume like SCC or JT. What happens is what type of cases one gets or what type of roster it is, he gets assimilated. But from it could be gathered easily that you have been reading the judgments. That's a spirit. I would like that. What is that key mantra for that? Number one. Number two, how do you assimilate all these facts together? And number three, why I'm taking connectively, after the session, I could gather it, that you will be able to take all these questions in one go. And number three is, how do you assimilate the facts along with law together? That's another fascinating fact which I have been fascinated. And without all these three questions, one fact after this lockdown is, yes, we were locked down in our own houses, but the lockdown has taught us one thing, that there is no boundary as such. We are from Punjab Haryana High Court and you are at Madras. We are connected together, we are sharing the knowledge. As we all say that sharing is caring. So all these three questions, then we will take another few general questions, no questions which have been posted on the chat box.
Yeah.
Yes, sir, your take.
Yeah, see, I told you that I have been doing this from the year 1991 onward. So what happens is that to start with, you will not understand anything. So if somebody starts reading a journal, say from this week onwards, they will not understand anything. It will be like dropping them in the middle of the sea. If you feel like that, you have properly started. That's the indication. So what happens is you have to start reading this methodically. It will not be possible to do it in the beginning. And therefore, the best way to do it is to have a separate notebook. You can have your own way of doing it. You can split it as civil criminal. In civil, you can have CPC, transfer of property, specific relief, evidence act pertaining to civil cases, rent control cases, etc., etc. In criminal, you can have different headings like CRPC, NDPS, habeas corpus, etc., etc., etc. And every time you can choose 2 or 3 journals, 2 or 3 good journals, You know what is a good journal insofar as your state is concerned. And apart from that, you can also have an SEC. So what you can do is every weekend when things come, just brush through it, just go through it. Because, my dear friends, two things will happen. Once your practice picks up, or you become a judge of a court, you will virtually will not find time for all these things. That leisure goes. So therefore, it is very important that you do all this in your formative years for the purpose. So once you pick up this practice, you become an expert in finding out a ratio within a jiffy. It's easily possible, and it does not require a huge intelligence. It is more a practice which your brain requires. So if you do it over a period of time, you will be able to easily update your law in your pad, in your notebook, whatever is convenient to you. That's why I was making a reference to this book of Justice B.S. Chauhan. These miscellaneous law references were a shocker for me. He had something like 569 heads under which he had been noting down the march of law for a long period of time. So if you do that continuously, it is possible that you get into the grips of all these things. This is all by way of a practice. You don't require to be a brilliant person. There are only some who are endowed with all those qualities. I'm not the one with that. I have developed myself only with this practice. So if you make it a regular practice, week after week after week after week, like your muscle memory, which you get by doing regular exercises, this brain memory starts operating, and you will feel like you are missing something if you have not read the journal at the end of the week. So this is something which you have to start at a very early stage and make it a practice. Whatever comes, no excuses. Whatever is the situation, whatever comes, I will not leave to the court on Monday without completing my quota of the journals which have come this week. If you do that, I'm sure that every one of you can do this. This is not some rocket science. This is something which comes out of a practice. So when doing that, you will always, in order to find out the ratio, you will also be able to assimilate the facts of the case. With some judges, it is very easy to find it out. For some judges, it becomes complicated to find out. But then, as you practice, you will be able to easily get it. Thirdly, as I always said, that the law is only for the facts. And don't try to put the facts into a law. Never do that. It will never work. There is a trend like that. That's why I'm saying. That's why Fali said that it's a case law diarrhea. So never do that. This must help you in the development in your knowledge on law. This should never come in the way of you independently assessing the facts of the case along with the substantive law and the procedural law. So it is, I think, more by way of a practice that you can do it. And there is nothing great about it.
So that only speaks the volume of humility. But I will just read few of the chat box messages. Meanwhile, I will also ask certain questions. Advocate Vikashshil Verma says, really never heard and witnessed such a session before it. It's an all-round session. Thank you for the session. Mahendran, it's a pleasure session. Tiredless lecture. Sir, you still look after this session, still very energetic. Sunil Kumar Bangri, thank you for your erudition on the contemporary laws in March ahead. Then it's Karun Shri. Very wonderful session. Your knowledge is wonderful. Sharing for the knowledge. So the next question would be, like, there are too many doctrines which come across, like we discussed today, doctrine of maturity, etc. As a young lawyer, it has always been to understand the facts first, understand the doctrines second, or one should go by the statute, the rules, the section to understand the things. What is your take? Because the way you have addressed the entire gamut of affairs, I can very well understand that it looked as a seamless effort, but I think the day before, the day after we just settled on the issue, I think you would, during this lockdown, you just locked down yourself within a room and you were just assimilating the facts so that it could be put across to this thing. So how was that done? Just a few words on that.
Yeah, see, many senior advocates, many of the veterans, the great jurists, all of them have unanimously said one thing, They have said that as a junior advocate, you must be a master on two things in the case that has been given to you. You must be a master on the facts of the case that you are handling, and you must be a master of the law which pertains to the facts of that particular case. These are two things which you have to develop as a habit at the formative ages. So it's very important that you become a master of the facts, and you also become a master of the law that pertains to these facts. So if you start doing that, once you strongly develop this character in yourself, then every time when you get into a case, you will be stronger, you will be getting more and more stronger on the legal side also, on the law that is involved in this. But that is not enough. That is not enough. Nowadays, I will give you a very easy thing. If you get into the YouTube, see, we keep complaining about the scientific developments and how it is killing our creative skills and all that. All that is there. But it is always important that you also try to take advantage of the electronic, the science. Today, if you go into YouTube, wonderful lectures have been given by stalwarts on various subjects. I always felt that it is easier to understand and assimilate by hearing than reading. Because if you are to read, by the 5th or 6th page, you will start feeling tired, or you will feel sleepy, or you will be disturbed by something. But when you get into a talk on a subject, on anything, which is available abundantly in YouTube, if you get into it and you hear such stalwarts, you will be able to understand a lot of things without really getting into the book. The moment you hear all that, to take it as notes. After you take it as notes, then get into the book. You see what is involved, what is that he's saying, what is he talking about this doctrine of mutuality, what is he talking about this manifest arbitrariness. So where is it found? He is referring to some judgments. Where are those judgments? Read those judgments. You become a master of that. So therefore, today the opportunity is even more than what it used to be for us or generation before us, because there are lots of people who are willing to share their knowledge in platforms like this. So if you go through carefully all the various topics that have been spoken by real stalwarts in law, you will be able to pick up one or two important things from that, work from there. If you are able to allot or devote some time to this on a regular basis, at least once in 2 days or 3 days, by the end of 5 years, you would have assimilated, you would have taken in a lot of things, even without you realizing it. And I'm telling you, you will be able to take so much even without really reading through each and every book. You will be touching the book only for the purpose of educating yourself more on the subject. So, in order to go to the book, today there is a platform called as a YouTube, which is available, where there are stalwarts who talk about it, who talk so well, who beautifully enunciate the law. If you hear it, you will get that inspiration. From there, go to the book. So it all depends on the ways and means. At the end of the day, as somebody said, that to be a successful lawyer, it is the industry alone which will take you. So hard work does not stop with you working hard in the office. Hard work also is developing your knowledge in law, because till the death, we are students of law. Nobody is an expert in anything. Nobody knows more than what the others know. So therefore, till the end, you should develop this habit. Once you do it, I think you will be in the grips of law. As Justice Basant, retired Justice Basant used to say, even a donkey will talk on law if somebody has a 40-year, 50-year exposure on law. It's nothing great. You are day in and day out exposed to this. But the formative years are very important. That is where you start this practice, and it will automatically lead you there. There is no, you don't need to, you will not even realize. In 25 years, you will find yourself in the top. So therefore, these are some characteristics which you have to develop further.
So only last question. How does a lawyer master the facts? What is how to present the facts in a chronological manner? How to assimilate that?
Yeah. When it comes to advocacy, one of the most important aspect of advocacy is assimilating facts. How do you do it? See, basically, when a client comes to you, he starts telling you about his problems, about his case. You cannot expect the client to do it in a chronological way. Talking or putting it in a chronological way itself requires training. It does not come automatically. So when a client comes to you, he starts telling his story to you, and he jumbles. The way in which he tells it, he goes to the last part, he goes to the beginning part, then he gets into the middle part. All that is jumbled. You slowly start patiently listening to him. After listening to him, you will have to assimilate all this in your head. So it can either be the client talking to you, or it can be the documents that have been given to you for the purpose of understanding a case. So once that happens, you have to jot down notes. If it's possible, you have to prepare the list of dates and events in a chronological manner. Once you do that, and that's a big practice that is followed by Fali as Nariman even today. That's something which is followed by many. In fact, draft after draft after draft goes when these dates and events are being prepared. The final dates and events that is in his hand is enough for him to make. So therefore, you'll have to, that is the beginning point of assimilation. So you get it from the client or get it from the documents, then you jot down, then you structure it in accordance with the chronological order. Once you do it, there is a lot of clarity on the facts that are before you. Yes, these are the facts before me. Now, what is the problem? This is the problem. This is what the client wants. This is the relief the client wants. Okay. For these facts, what is that the law is saying? What are all the laws that are involved in what the client has said? Contract Act, Transfer of Property Act, the Civic Relief Act, Limitation Act, Civil Procedure Code. It can be anything. Criminal side, Code of Criminal Procedure, criminal rules of practice, etc., etc. So slowly bring it to that. Once you do that, you are very clear about what are the facts and what is the law that has come into it. Once that happens, it is very easy for you to put it forward in the court at the time of arguments. A person who is not good in drafting, in my very humble view, can never be a person who can really put forth his case well in the court. A person who has assimilated facts, who is thorough with the facts, who has properly understood it, is the only person who can put forth a good argument before the court. And it cannot be done by a person who sort of understands it in a jumbled way. You will find some advocates who are very, very good in law, but when it comes to arguments before court, you will find them to be like scrambled eggs. Meaning, they will know the issues in their mind, but when it comes through their mouth, there you will find that it is completely disoriented. I have found this in many of the senior advocates also. The reason why it happens is that because they have not developed this practice of assimilation, law, and then arguments. It's very important because it's a brain thing. Again, I am saying you don't need to be intelligent for all these things, or you should be a genius for all these things. This happens by training your mind, completely training your brain for this. If you start it from a very beginning stage itself, by writing pleadings, by writing plains, written statements, affidavits, you have to, I have even today, if the steno is not available, I will write the order, 30 pages order I have written in my hand. How did that come? That came because I am trained to do this again and again. So therefore, it's very important that you focus a lot on pleadings. Pleadings is the most important foundation a lawyer can lay if he wants to be successful in future. And that is the lawyer who will be able to really present it well before the court. You may be a master in law, you may be anything. But if you are incapable of putting it well before the judge, you have missed the bus. So therefore, it's very important that you start practicing this from the very formative years, and it will take you a long way when you become a successful lawyer.
Thank you. The questions will keep on just seeping in the mind, and we will like that one should do. The way you were putting the things across, as you said that one should follow the YouTube. I was also listening to a YouTube channel on a program. They said that let's assume anybody is working, he's an MBA or an advocate. Everybody has done that degree, but until unless he assimilates the facts in the right sense, it doesn't sharpen the tools, it doesn't bring all things equal. And that is the key, what makes, despite the fact that the degree is same, but the amount of pay one gets, the amount of fees one gets, the amount of adulation one gets, it is only because of the practice and knowledge. As you were just discussing, I also thought that, I was just jotting it out. I thought, how many M's you have used? You said you have to master the facts. You have to be manifestly clear. Then you said there has to be mutual admiration because of your hard work. Then you said that the muscle powers of the brain has to be improved. And then you said that it has to be a mutual love. For the studies, you have to be passionate for that. So any words would fall. In fact, short, the way I have been doing these webinars, the way the messages are just coming forth, that it's a wonderful session. It rather gives me a trigger point in my mind that we can have a session on how to become a good lawyer, how to assimilate the facts. Because the YouTube, as you were saying, that one can see the YouTube. We have also started a YouTube channel on this Beyond Law CLC itself, which we have been uploading, and by grace of God, we are touching around 1,500 subscribers, and we have already views of more than around 15,000. So people are admiring. I have been receiving phone calls, or in fact, the team is also receiving these phone calls to the effect that what they do is that they take these YouTube channels in the morning walk, because they're in the lockdown, etc. They just put their phone on with the headphones on, so that they can learn one lesson in that phase.
True.
I suppose your program would be one which would be a hit on the YouTube. Facebook, we are already live on this. I forgot to tell you that we are live on the Facebook. Okay. It's a wonderful session. I will ask a dear friend of mine, a younger brother like mine, Ahmed George, who frequently writes on Bar and Bench and Live Law. Today, as I said, he has written on Bar and Bench the article of the wrap up of what happened in the Delhi High Court. But you didn't give 1 month, you gave into the years and years, and what is also to come. As we say, aaj kal aur kal. That kal, aaj or kal. You have told what was yesterday, what is today, and kal, what is going to happen. It's a wonderful session. Over to Ahmed George.
Right. Good evening, everyone. Well, I am frankly overwhelmed by the depth and scope of the talk today. I think that with the onset of COVID-19, even the most conservative amongst us have realized that life in general and the law in particular are far from immutable and must always be responsive to the possibility of rapid change and evolution. As Justice Venkatesh pointed out at the outset, this very webinar is testimony to the transformative effect that COVID-19 has had on our manner of social interaction and knowledge exchange. Now, in this background, I believe Justice Anand Venkatesh's lecture today was all the more relevant and poignant on a thematic level. I would especially like to thank Justice Venkatesh for having dealt with aspects of legal practice and procedure, in addition to the developments in the substantive law. While all the issues which have been flagged give us much food for thought for further debate and discussion, I was particularly enamored by the reference to the problem of multiplicity of precedents, an aspect which is usually given short shrift in most of our contemporary discussions. In fact, if I remember correctly, Justice Sanjay Kishan Kaul, while he was in the High Court of Delhi, had briefly flagged this issue in the case of Rajiv Joshi versus Union of India, where he had observed that just like the docket explosion represents a challenge for us, an equally big challenge is the problem of case law explosion. And he remarked as to how on the click of a button, you are able to generate a lot of case law, which is then cited indiscriminately before the court. In terms of the substantive law, we are grateful to Justice Venkatesh for his detailed and comprehensive review of the innovations and advances witnessed in our legal system in the recent times. Many of these, such as manifest arbitrariness, while being relatively nascent in their origin and in their defined contours, have already signified a massive normative shift in the court's stand on the extent of judicial review and has significant repercussions for the future of our polity. Now, one has come away from this webinar with greater confidence in terms of one's understanding of the crucial issues at play in our legal system, and with a reduced feeling of a disconnect with the law that many of us as practitioners might have experienced in the past few months. I once again thank Justice Anand Venkatesh for having taken the pain to have addressed us today, and which pain is self-evident in the multifarious areas of law and related judgments that have been touched upon today. And I hope and pray that he will share his precious time in this regard in the future as well. Thank you so much, sir.
Thank you, thank you, thank you.
Thank you, sir. And tomorrow we have a session on global military justice reform and military litigation in India. As we said that we try to bring best of the speakers. Tomorrow we have Eugene Fidel. He's in Yale School Law, a president of Emeritus National Institute of Military Justice. And then we have Aishwarya Bhatt, the senior advocate who fought the case in respect of the persons, the ladies, their rights for the short commission, etc. And then we have Major Navdeep Singh, who is also the founder president of AFT. The tomorrow session, again, we will have at 6:30 because we are having one of the speakers from abroad. Therefore, invariably, the time is either the slot of 5 or 6. But since he's coming from abroad, we have scheduled the time for 6:30. So since we have brought you on the platform, we have good webinars. We have sports law and beyond. We are having in that day senior advocate Mr. Puneet Bali with Yuvraj Singh, the former cricketer of India. Then we have Tanveer Ahmed and Raj Khosla, a famous director in the film industry. So we are trying to rope in the persons who are best in their field so that people can learn during this lockdown period. Thank you, everyone. Stay connected. You can all subscribe to our channel of YouTube, Beyond Law CLC. For the previous webinars, they have been uploaded, and of course, the subsequent webinars which will come on the platform, we will upload them soon. Everybody, thank you. Stay safe and healthy. Thank you, sir. Thank you, Amit.
Thank you so much.